Kari Lake going back to trial. Gateway Pundit has an update for us. Will be had May 17th, 18th, and 19th. And this comes after Kari Lake and her team submitted a request for a status conference. We'll read through the status conference request, and we'll take a look at a couple clips that came out from the proceeding itself, where there were some interesting drops saying there was new evidence about the 2022 midterm elections here in Arizona. And so before we take a look at the hearing itself, I want to share with you what was filed on behalf of Kari Lake and her team, submitted May 4th, 2023 from Blem Law and Kurt Olsen. We remember these individuals from the previous trial, and they submitted this in the same case that went up on appeal all the way to the Supreme Court of Arizona and got remanded back down. So once it landed back down in the original Superior Court, which is where the trial was that we covered here, this is what Kari Lake submitted. She said, hey, we want a status conference. We're going to have a lot of issues to parse through here, so let's get something scheduled. So she submitted this. She said, Kari Lake asks this court for a status conference as soon as possible. We need to address further proceedings after the remand from the Arizona Supreme Court. Additionally, because many of our attorneys live far away, we ask that this court hold the status conference by telephone or video conference. The motion is supported by the record. They tell us that there was a series of rulings. Previously, the court dismissed all 10 counts of Kari Lake's challenge. The Court of Appeals affirmed the dismissal and said, yeah, it should have been dumped, but the Arizona Supreme Court reversed the dismissal of one count, which is a pretty important count, signature verification, to allow further proceedings to have essentially another trial on it. Today, the Supreme Court issued a final order in the appeal, directed its clerk to enter, saying that Lake now submits this request so that we can have a hearing, so we can decide what to do with a bunch of different issues, so we can streamline further proceedings and address issues that are likely going to arise. Some background. We know that Kari Lake brought a 10-count challenge after the election was over. There were several rulings. In an opinion, the Supreme Court found a certain way. In another ruling, the Arizona Supreme Court confirmed the Court of Appeals for everything except that one very important count, count 3, for signature verification. The Supreme Court disagreed with this court's finding that latches barred count 3 because Lake could not have brought this challenge before the election. Kari Lake was originally dismissed because they said, well, you can't complain about the signature process now. You should have complained about it before the election started. And now, since you're complaining about it after the fact, that's an invalid claim. But the Supreme Court said, wait a minute, petitioner can prove her claim as alleged and establish that votes were affected in sufficient numbers to alter the outcome of the election. Based on competent mathematical basis, to conclude the outcome plausibly would have been different, but it can't be simply an untethered assertion of uncertainty. So we have a new standard now, and this is what Kari Lake and her team are going to have to prove. The Supreme Court issued its final order, directed the clerk to issue the mandate, and here we are. So now Kari Lake and her team says, look, Judge, we've got a new trial essentially coming up on this issue. We weren't allowed to move that one forward. We want to do it now. And so we've got to get this scheduled. We've got to decide several procedural and evidentiary issues. These additional issues may arise from the remand. Parties to an election contest may petition the trial court to inspect the ballots. Here, Lake intends to petition this court to inspect the ballots verified by Maricopa based on new evidence that came to light in 2023. New evidence. In addition, Lake has filed a special action in this court to compel Maricopa to produce ballot envelopes and related public records for the 2020 election in response to Lake's request. The new special action thus directly relates to facts underpinning the remanded count. It goes directly to signatures, and therefore Lake intends to consolidate the new special action with this case. So she's filing to go get access to inspect these ballots in a parallel case, but she's saying we're ultimately going to merge these two things together. In addition, pursuant to the Supreme Court order, the government may move to dismiss under Rule 12b-6 for failure to state a claim for reasons other than latches. If they have another basis for dismissal, then those issues should be briefed and decided first. So you can dismiss this for another reason, but not for latches. Latches meaning you are barred from bringing your claim because you should have brought it before the thing happened. If you see a rule that's problematic and you play the game anyways, you can't complain about the rule after the fact. You should have challenged the rule before the game started. But they can't say that now because the signature verification, part of the problem with it is the implementation of it. You might say, well, if they would have followed the rules, it would have been fine, but the methodology by which they did the signature verifying was problematic, and you can only discover that after an election. A status conference would likely aid the parties in setting a procedural calendar for further proceedings. Here, the plaintiff Lake is also contemplating a motion to reconsider the dismissal of the logic and accuracy testing under another rule. She may bring another new and separate action under other rules, federal and Arizona constitutional claims. Either party could consolidate all of these cases, and so Kari Lake is intimating to the court they are coming in hot. Because of the exigency of resolving election contests before a new term begins, we need expedited hearings on this. And although the election contest statute does not expressly rule out civil discovery, the timing often does not allow discovery. But that exigency is now lacking. So now we seek discovery as part of either remand. Previously, Your Honor, we had very limited time. We had to move quickly because Katie Hobbs was going to be sworn in and take the oath and all the things and become governor. And she's now governor. And so we don't have that same exigency. We don't have that same urgency to go after these materials. So now we have time to go after these materials. So we want to do that now. Similarly, a new action for constitutional violations would have the benefit of civil discovery. And we want to get to the bottom of this. We need to discuss it at a conference. So to aid the court, we ask that we submit a joint status report at least 5 days. Here is a request to make this telephonic. Some counsel live in DC and Seattle, so we want to do this by phone. Conclusion, judge, please grant us a status conference. And of course the judge did, said no problem, let's hop on a call and do it. And it was done telephonically, and the judge did sign an order, and we have new dates coming up. But let's check in and see what the hearing held, what it sounded like. CannCon at CannConActual posted this on Twitter. Says that here is one clip from Kari Lake's lawyer, Kurt Olsen, saying we've got new evidence in this case.
There were extraordinary findings of misconduct that are directly related to the court's findings in its December 24th, 22 order dismissing that claim. The issues are of such an extensive nature. They show that Maricopa officials conducted secret testing on the tabulators on October 14th, 17th, and 18th. That's after the logic and accuracy test was certified, that those 260 of those 446 tabulators failed that secret testing, and that those tabulators were then used in the election. There were extraordinary...
So the machines were problematic, and they used them anyways. Pretty interesting new evidence, and I don't know exactly where they got that material from, but certainly part of discovery will be the transfer of materials that would illuminate that issue, and we're looking forward to seeing what comes out of it. So we know trial is going to be scheduled back on May 17th, 18th, and 19th. We saw the clip. This is a little bit about what the signature problem might entail. You see here, we have a person's recorded signature as to what it should look like. And then we have another signature that doesn't look anything like this signature. Apparently, these are both from the same voter, and one signature doesn't look anything like the other, but it still counts. They still say, no, it's good. Yeah, that's close enough. So what percentage of a match is that? Is it 0%? Pretty much. Maybe 5%. That S there kind of looks like that. Maybe 88 versus this one looks like a full name. So if the mail-in ballots are supposed to be signature verified under law, they're supposed to be a closer match than this, and they're supposed to get about what a certain threshold of accuracy. If it's way below that under the threshold and it's not in compliance with Arizona law, how are those ballots valid? They're not. So this will move forward. They tell us that the election procedures manual, it says counties may in their discretion conduct additional pre-election testing as long as they're included with the participation from representatives of the recognized political parties. If the county conducted further testing without party representatives in public notice, that would be illegal. So we'll be back here, of course, to cover this 3-day trial starting May 17th here in Arizona, which will be next week. That will be coming up soon, and so should be interesting to watch. We'll see what happens in Arizona. Hopefully we get some good news.